Thanks everybody for coming to this additional Women's Network event featuring one of the two women Supreme Court judges in the country. Just a few initial things in addition to the welcome. You have all been muted, and that will continue until we go to the Q&A session. If you do want to ask questions, which hopefully you will, then please use the chat box and select Tim McNally. Put your questions to him, so he will moderate that for us. At the end of this evening, if you still have an appetite for a little more Zoom, you can swap over and join Thursday table, of course. So having said that, that's all my intros. So I would ask Judge Tim Harrington to introduce Lady Arden.
Thank you very much. It's my great pleasure to introduce the Right Honourable Lady Arden of Heswall, who's kindly agreed to talk to us this evening. Lady Arden has had a distinguished career at the bar and on the bench. She practiced from Erskine Chambers, the leading set for company law and insolvency advice, and was recognised as a leading expert in that field, becoming a Queen's Counsel in 1986. When Mary Arden started her career in the 1970s, women in the higher echelons of the bar and the judiciary were very rare. For example, in 1979, there had only ever been 3 women appointed to the High Court bench, all in the family division, and the latest appointee, Dame Margaret Booth, who died recently, was only the 10th woman ever to have become a QC when she took silk 3 years earlier in 1976. In 1993, Lady Arden had the distinction of being the first woman to be appointed to the Chancery Division of the High Court. The Chancery Division deals with business and property matters, covering not only matters involving private individuals, such as contested wills, trusts and land law, but also company law, insolvency and commercial disputes. At the time of Lady Arden's appointment, there had still been less than 10 women ever appointed to the High Court. Lady Arden's husband, Jonathan Mance, became a High Court judge later in 1993, and they were the first married couple to sit on the High Court bench. Jonathan was the first to make it to the Court of Appeal in 1999, and Lady Arden followed a year later, which made them the first married couple to sit in the Court of Appeal. There had been earlier appointments of women to the Court of Appeal, but it's worth mentioning that when the first woman was appointed in 1987, the law had to be changed to permit a female Court of Appeal judge to be called Lady Justice rather than Lord Justice. Lady Arden was appointed to the Supreme Court in 2018, replacing her husband. She was only the second woman to be appointed to the highest court in the land, and she is now the only female Supreme Court Justice, following the retirements of Lady Hale and very recently Lady Black. And I'll finish by just mentioning a little bit about the Supreme Court. It deals only with those cases which raise points of law of general public importance. Permission to appeal from the Court of Appeal is sparingly given, and the court hears only about 60 cases a year on average. A Supreme Court Justice has to deal with a wide variety of cases involving difficult points of law, and is expected to deal with matters well outside the particular areas of expertise they built up in practice. That is illustrated by a few examples of the recent judgments that Lady Arden has delivered, covering areas as diverse as the application of gaming duty to free chips given to punters at a casino, the rights of residents in the UK of a non-EU national where his child is a UK resident, the right to register land as a village green, and the standard of proof required when a coroner decides whether a person has committed suicide. No sign there of anything to do with company law or insolvency. Well, nobody is better qualified than Lady Arden to speak on the topic of women in the senior judiciary, and we now look forward to hearing from you.
Thank you very much, Tim, and welcome to everybody. I wish I could see you all. I'm sure that I know many of you, and I'm very delighted to be given this opportunity. It's now 102 years since the Sex Disqualification Removal Act was enacted. In the years immediately after the Act, that's 1919, progress for women in the legal profession was quite promising. In 1921, the first women were called to the bar And in 1922, Carrie Morrison became the first woman to be admitted to the role of solicitors. Yet despite these early successes for women, there were lingering obstacles on both sides of the Atlantic. Even the famed Justice Ruth Bader Ginsburg, the late Justice of the United States Supreme Court, had to overcome great resistance to get into the profession. The Dean of Harvard Law School pointedly asked her at a dinner to which he had invited her with other law students, "Why are you at law school, taking the place of a man?" And she had to get up and answer. Ruth Bader Ginsburg went on to graduate from Columbia. In 1959, she transferred in order to be with her husband. She got the top marks, and yet when she applied for her first job in a law firm in New York, she was told, "We would love to have you, but what would our wives say?" RBG became a public figure. She went into the academic profession and then appeared in court in civil liberties cases. She was renowned for her judgments when she was a judge and for the way she took so much time and care to answer a question. You had to listen very carefully. But these early experiences epitomize some of the barriers that women have faced in the law profession in the past. Even in 1971, when I became a barrister, women without connections at the bar were still being openly discouraged from attempting the bar as a career. In 1973, a popular introduction to the law for students was entitled "Learning the Law" by Professor Glanville Williams. This advised women that it would be, quote, "folly," end quote, to read for the bar unless it was first established they could get help from barristers already in practice. The reasons given were pretty comprehensive. Barristers would prefer to give a seat in chambers to a man. Clerks would prefer to build up a man. And solicitors and clients would be prejudiced against women. According to Professor Glanville Williams, women found it harder than men to face a court. They, quote, "are not generally prepared to give battle unless they are annoyed," end quote, and that a woman's voice, quote, "does not carry very well." Despite these attitudes, women have gone from strength to strength. The percentage of women at the bar is now about 38%. Women solicitors are now 52% of the profession. And to take one example, the Court of Appeal is about 21% women. And then currently in the Supreme Court, as you know, there's a lower percentage, but it has been rather higher. Now, progress for women has been a very long time coming, but our success has been made possible by the hard work of predecessors. But can we now safely say that we have achieved equality with men in the practice of the law? Have we cracked it? Scientist Sarah Gilbert, who has been working on the Oxford COVID vaccine, was asked recently in an interview with the Financial Times whether she regarded herself as a woman scientist. She said, "No, I regard myself as a scientist." So that indicates that she didn't think there was any problem. But in my view, as long as we have to raise this question, true equality will not have been achieved. So why are we still asking the question? The answer is there are many issues that remain even after a century. To name but a few, anxiety is often expressed about the level of equal pay, the low numbers of women who are partners in city firms, that's 32% as compared with 52% in the profession as a whole, and continuing harassment of women lawyers, a lot of publicity given to that just before the lockdown. It's concerning that these issues still exist 102 years on. But looking at what continues to get in the way of women's success and what can make a difference, because it's important to ask these questions because women must make progress, and so it's worth reminding ourselves why diversity matters. In the judiciary, diversity matters because diverse minds achieve more. Until about 15 years ago, women judges were still being asked whether there should be women judges. In a recent edition of the BBC's well-known radio programme, Law in Action, Joshua Rosenberg posed a slightly different question to Lady Hale, then President of the Supreme Court. How did she select the panel of 5 judges for any particular appeal? Well, her response was, not surprisingly, that she chose specialists in the particular area, but then she said, as well as non-specialists, adding that the non-specialists can challenge what the specialists say. Rosenberg then asked whether it made a difference which judge sat in a particular case. Did it matter whether they had a particular specialism or not, and whether they were a man or a woman? And Lady Hale replied, we all bring our experiences of life to judging. What's more, if you have 5, 7, 9 different legal minds all trying to get to the right answer to a particular problem, they will come up with something better than any individual alone. Something greater will be forged out of the deliberation and discussion between diverse minds, diverse because of their different experiences in life. So there's an old chestnut about whether women decide cases differently from men. Baroness Hale confirmed that women do sometimes decide them differently, but not often. There will be the odd situation where the judge's own personal characteristics are relevant to judging a case. Now, some years ago, there was rather an interesting incident when Lord Neuberger was the president. He proposed an experiment. He asked a professor from Durham University, Professor Erica Rackley, to provide some students, and he would give them a number of anonymized Court of Appeal judgments and ask them whether they thought they were written by men or women. What do you think the result was? The result was that the students got 49% of the answers right, i.e. pretty much 50-50. So Rackley's conclusion was that the experiment showed a great deal about the assumptions which people make when judges act. But in my view, this experiment simply asks the wrong question. The issue is not whether women have a different writing style, it's whether they make a distinctive contribution. And it shouldn't be one which is necessarily based purely on gender. It's about whether women judges are making points that other people are not making. In the last few years, there's been much more enthusiasm for diversity than I recall when I first started out, and it has been a long time coming. And in the judiciary, this is partly because there's no economic driver. If you have a firm of solicitors, the clients can sometimes pressurize the firm to ensure that there's a proper representation of underrepresented groups on the team who deals with their work. But this simply isn't the case in the judiciary. So diversity has been a long time coming. And then finally, on a point of principle, in a society such as ours, which is plural, democratic and governed by the rule of law, it is important that people should be treated equally, irrespective of gender or any other difference. So that's why we should have women judges. So what was my experience? And I've headed this part of my remarks 2 steps forward, 1 step back. Despite the demonstrable benefits of diversity, the lack of diversity has remained an intractable problem in the judiciary until very recently. Even today, measured by the proportion of female to male judges, the UK lags well behind other countries internationally, and even the common law countries. Among the signatories to the European Convention on Human Rights, it's 3rd from the bottom. In senior courts, the picture is even more serious, and I will highlight 1 or 2 particular issues where progress has often seemed like 2 steps forward and 1 step back. And those 2 areas are recruitment and childcare. On recruitment, the Judicial Appointments Commission was set up in 2006 to make the appointments process clearer and more accountable. Yet in the first 3 years, the number of women High Court appointments dropped by 20% to 13%. Appointments have to be on merit, But the question is, how do you define merit? Very often a problem. Today, it is permissible, for instance, to stipulate that an applicant for an appointment in Wales must speak Welsh. Yet merit is still defined without reference to the benefit of appointing a member of an underrepresented group, as women are. Another problem is the tendency to externalize the problem. Oh, we don't have many women because the problem lies elsewhere, at the bar, for instance. Women must have been disadvantaged at some earlier stage in their career. They even suggest sometimes that few women get a good law degree, just as few women study maths or engineering. And then we can turn to childcare. As a rule, women bear the brunt of bringing up children. Not always the case, I do appreciate, but in many families it is. There was a statistic recently about the lockdown that mothers spend 70% more time with their children than their fathers do. It's quite something to think about. And there has, during the lockdown, when there's had to be homeschooling, enormous pressure on women with jobs to do, because they've had to be in charge of the children for much of the day and give them homeschooling, and yet try to keep their jobs. So it's been a very, very difficult time for working women, and I hope it won't mean that women don't make the same progress in their jobs as they ought to. Cultural norms intersect here. They often mean that women are still expected to do the lion's share of parent care. So it's not surprising, really, that some women in the legal profession still express a lack of confidence of whether they will be able to engage in the same way as men if they do have a family, because they will not be able to attend all the same events after work as a man would do. Barristers are self-employed. They rarely have the support that an employed person would have from their own firm. And even in firms of solicitors, working practices often fall to be organised in the way that fits in with women's lives, not so at the bar. When I was at the bar, I proposed a childcare facility close to the law courts. The main reason why this didn't succeed was that women did not want to bring their small children into central London. Recently, there was another attempt to set up a creche in the Inns of Court. This similarly failed because, among other things, people practicing in the inns were concerned about the noise that the children might cause. It's often said that attrition, that is, young women leaving the bar, which they do in their early years of practice, is the reason why there are fewer women to appoint as judges. I'm also told that in solicitors' firms, women often do not want to proceed to partnership because of the responsibilities it brings. These responsibilities simply are not women-friendly. Apart from issues around recruitment and childcare, there are many other barriers to progress, too many for me to go into this evening. But to name just a couple, it's been shown that women's judgment and competence are questioned more often than men, and that men tend to take what I call airtime, more airtime than women, and frequently interrupt women than they would do as a man, or even ignore them. There was a recent comment by a transgendered scientist saying that since he changed gender, he was not getting interrupted as much. That was the big change. In one widely circulated cartoon, a woman's proposal at a board meeting is ignored until the man makes the same proposal. And that brings me really to the largest and most intractable problem of all, which is unconscious bias. And this is a great subject because there's been so much research lately about unconscious attitudes. Daniel Kahneman's Thinking Fast and Slow is a wonderful read, and it shows that the brain has a dual process. System 1 is fast, intuitive, associative, metaphorical, automatic, and impressionistic, and it can't be switched off. System 2 is considered, reflective, slow, deliberate, and effortful. This has implications for interviews for jobs, where decisions can often be made on the intuitive or fast judgment, and candidates who impress an interview may well do so on much less evidence of merit. Unconscious unconscious bias operates in so many fields, not just the legal profession. In 2017, the Harvard Business Review published an analysis of video transcripts of Q&A sessions, which showed venture capitalists posing different types of questions to male and female entrepreneurs. The analysis showed that, among other things, the questioners tended to ask men about the potential for gain and expansion and all the rest of it, and they asked women about the potential for losses. They adopted a promotion orientation for males, focusing on hopes, achievements, advancement, and ideals. But when they questioned women, they embraced a prevention orientation, concentrating on safety, responsibility, security, and vigilance. I did laugh that when the Supreme Court was set up, it had a new building, it all had to be laid out, the courts designed and everything else. And who did they give the job of designing the curtains and carpets to? The women contingent. New developments in society often depend on data. And this is another problem for women. Data can often be based on the purely male experience. I only hope this isn't so with the COVID-19 vaccine. I can't believe it could be, since we have a scientist, Sarah Gilbert, who is a woman. In a recently published book called Invisible Women, Caroline Criado Perez points out that some of the drugs which are commonly prescribed for high blood pressure, so as to reduce mortality in men, actually increase it in women. She gives numerous examples of the way that women are left out of data on which some of our most important decisions are made. Research in the US has shown that women's contribution to science has not been properly recorded because they're often not named as co-authors on research papers. On a very light note, as I struggle to find a place for my handbag when I get into the driver's seat in a car, or when I used to, I wonder if any car designer anywhere has ever thought of a woman or been a woman. I will probably have to wait until it becomes conventional for men to carry man bags as well. Women are making some progress, but breaking conventions is really hard. The distinguished US politician Madeleine Albright was quoted quite recently in the FT as saying that there are plenty of mediocre men around, but for women to succeed, they have at all stages to be better than the men and to show it. In the legal profession, one good example of unconscious bias is that oral excellence is often associated with men rather than women. In a world where most judges are men, and men are not used to having a discussion on cerebral issues with a woman, the oral tradition of the bar has given men a natural advantage in terms of physical characteristics. And it's true that in the Supreme Court, there are fewer women appearing as advocates than men. I recently judged a moot in a university, and I asked some of the participants why they had chosen to go to the bar. The female competitor said she wanted to go to the bar so she could do justice in the courts. The male participant said to me that he looked forward, when at the bar, to his daily performance in court. But men's attitudes are not the only obstacles. Women too are susceptible to unconscious bias, and this can take the form of insufficient self-belief, what Lady Hale used to call the imposter syndrome, thinking you can't apply and do something. And today women still express a lack of confidence about whether they will make it if they go to the bar. So what works? What are the opportunities for women to achieve full gender diversity in the judiciary and the legal profession more generally? For me, it was vital to have a role model. And that role model may be known to some of you. I'd just like to say a few words about her. It was Rose Heilbronn, Queen's Counsel. She was an inspiration to me in my childhood. I grew up in Liverpool, and while I was at school, Rose Heilbronn was busy practicing as an advocate. The public flocked to the courts to hear her speak. They queued up in order to get in. We had hard copy newspapers morning and evening delivered to the door. And very many days there would be a headline about her court appearance, such as "Rose QC does it again." And people would look askance when I said I would like to be a lawyer, explaining how difficult it was for women to have a career in the law. That's what they did. But I knew that Rose Heilbronn had broken the mold. So she was my role model. And I'd just like to make 3 points about her glittering career. First, she was a trailblazer. She had, of course, enormous talent. She was the first woman to plead a case in the House of Lords, which she did at the age of 34, and her opponent was none other than the Attorney General, Sir Hartley Shawcross, Queen's Counsel. She was the first woman to take silk, taking silk in 1944 at the age of 34. She was the first woman leader of the circuit, the Northern Circuit, and she was the first woman recorder and thus the first woman to be a judge at that level. And later she became a justice of the High Court. The second point I'd make about her is that her experience was the experience of almost every woman who tries to succeed in a man's world. She suffered frequent indignities, but she responded with great dignity. She practiced in Liverpool, and in 2nd February 1940, she was elected to the Northern Circuit, that association of barristers which practices in the northwest of England. It is scarcely believable today, but women members of the circuit did not have the right to attend the regular dinners and circuit events, even when the dinners were attended by guests such as judges. Sir Michael Morland, the distinguished High Court judge and also Liverpudlian, explained to me that in about 1966, when on circuit at Lancaster Assizes, the then leader of the Northern Circuit, Alex Carmel QC, saw Rose Heilbronn dining alone and invited her to join the mess. She had by then finished her own dinner, but she got up and joined them. The group obviously had a great evening, and she started to be accepted by other barristers. So there's a moral here for women: never refuse a small act of kindness. And better still, that act of kindness led to all women members of the circuit getting the right to dine at circuit dinners on the Northern Circuit. Sir Michael told me another story, how on the Northern Circuit it was decided to have a dinner in honour of David Maxwell Fyfe, later Lord Kilmuir, one of the UK's chief prosecutors at the Nuremberg trials of the Nazi leaders, and the newly appointed Queen's Bench judge, Mr. Justice Ashworth, also from the Northern Circuit. Sir Michael was the junior on the Northern Circuit. Rose wrote to him saying, "Yes, please, I would like to attend the dinner. I'm a member of the circuit." But he had to write back saying that as she was a woman, she couldn't attend. Such stories do no credit to anyone when retold today. And the third point is, to get through all this, she must have had huge resilience. She had great difficulty despite her success in getting accepted. And in that respect, in very many ways, things have moved on. And we're now at a stage when women are invited to participate in professional and public functions without too much difficulty, and they are welcomed. Today, people tend to expect an organisation to have a few women members. However, her experience was probably not completely removed from our own, despite the passing of the years. And we have to have some of her resilience, in my view, to finish where she left off. So that was just a little diversion about Rose Heilbronn, because of the importance I would attach to having role models. But the good news is that the new generation is perhaps much more confident of its role and of cracking social norms. I recently received a photo of my hard-working daughter-in-law coming up to Pancake Day. She was tossing a pancake with one toddler under one arm and the other one holding up the plate, hoping to catch the one coming out of the pan. So that's really juggling home, job and family. But we need to have a critical mass of women in the judiciary for them to have impact and thus precipitate a tipping point in the appointment of more women judges. And to help us get to that point, there are one or two ideas I'd like to throw out, which you might like to talk about. The first is, let's recognise the importance of difference. Some of you will recall the comic strip, Charlie Brown. Lucy is the little girl who always gets in the way of the boys' games and spoils them. But Lucy knows her own mind. One day, Charlie Brown and Lucy are playing a game of baseball. Charlie is the team coach. Lucy misses all the strikes, and Charlie Brown goes off angrily saying, "We're never going to win." To which Lucy simply quips, "Sorry, I do it my way." So that's going to be our future. We women will do it differently, at least some of the time, and that has to be recognised. Women leaders behave differently, at least some of the time. They're often more interested in participatory decision-making and improving the working environment. And why not? Difference has to be seen as something positive. Diverse minds produce something greater than what was there before. Lucy may interfere with the boys' games, but she also makes a real contribution. And the next point I'd make is and I will leave it here, is champions, mentors and networking opportunities, please. This is a networking opportunity. Once women have entered the legal profession, much can be done to support and encourage them, but they often need a champion who will give them the same stretching assignments as they give to men and trust them with the more serious cases and highlight them for their good work. More mentoring also makes sense. I particularly favour more mentoring women to help them back to work after having children. In a way, I had it easier. I went straight back to the same chambers and there was a place for me to go. But many women have to restart their careers and find a new position. They need help to organise their work, to manage their relationships and in the best way, and to realise that they can get back to work and back to their own careers. And then there is reverse mentoring I'd like to mention. That seems to me a new measure in the world of work, which might really help. Not only does reverse mentoring enable senior members to learn from the newer recruits, it provides newer members with a glimpse of what happens at the top of the organisation, which gives them an advantage when it comes to promotion. Easier access to senior management is an issue for women. In my own chambers, for instance, there used to be an hour at the start of the day when senior members left their doors open and allowed the juniors to try out their opinions on them. And that was the way of making sure the know-how was spread and everybody acted collegiately. Finally, employers and professional bodies could actively encourage more networking between women lawyers. For members of the bar, the Inns of Court offer lunching facilities. And this, when we don't have a lockdown, is a good way to hear about what other barristers are doing or to get some advice. And how about a 1919 club? So those are some of the ideas. I'd just like to leave you with a couple of points. Chelsea Clinton, the daughter of Bill Clinton and Hillary Clinton, wrote a little book and she called it She Persisted Around the World. And she said that her book was for everyone who has ever aimed high and been told to step down, for everyone who's ever raised their voice and been told, quiet down, and for everyone who has ever felt small, unimportant or unworthy, something women have to feel from time to time. And her advice is, speak up, rise up and dream big. And then I'd just like to read one other paragraph, which comes from a book I was just finishing as we started, called Difficult Women. And the thesis of this book is that it's difficult women who succeed in change. And it goes as follows, and it has another message in its final paragraph that I would concur in. Above all, the difficult woman knows that no woman can fight all the battles alone, no matter how difficult she is. Sometimes she's tired and she's worn out, but one thing saves her, because a difficult woman should always find herself some other difficult woman. They will help her remember that she is, like hundreds of others before her, for hundreds of years before her, and that she can use her difficulty to make a difference. Together, difficult women, and I would say all of us women, can change the world. Thank you.
Oh, thank you, Lady Arden. That was wonderful. I know there are lots of people wanting to ask lots of questions, so I'll go first to Janet Berridge, who's a former chairman of the club, and indeed has done one of these presentations herself on how she got there. Janet.
Thank you very much, Val, and thank you very much, Lady Arden, for a very comprehensive but concise account of how you got where you are. I have to say that I totally endorse what you said about having people to help you. I don't think I'm a particularly difficult woman. I rather think that the gentleman of the National Liberal Club who suggested I might one day become chairman of the club thought I was going to be a little woman who'd just take their instructions and things would just carry on as they always had. But it didn't turn out like that. And thanks to teamwork, and I have to say a lot of the ladies here this evening and a lot of the men were very helpful. Anyway, that's beside the point. It's wonderful to have you with us this evening, and thank you very much. And I hope you won't find this too personal, but you said so much about childcare and the difficulties. May I ask how you solved your childcare difficulties? I mean, you have 3 children. Did you have a nanny, or what did you do?
Well, I have to say we were very blessed, because in those days it was possible to have a nanny. Now I think nursery nurses particularly want to live in their own flats, have their own cars, and it's more the vogue to take your children to nursery, and I think that's 10 times more hard work than having a nanny, because you don't have to rush out of the house with the child, give the child breakfast, of course, first, dress the child, and go off to a day nursery for 8 o'clock in the morning, as I see that the young do now. So they had a much harder time. And I was very fortunate, because the first nanny stayed 6 years and the second 9, and the next one umpteen years as well. So we didn't have too much loss of continuity. Just very lucky, but it was essential, and I'm deeply grateful to them.
I'm sure you are. Thank you very much.
Thanks. Next up is a fellow judge, Nicola Williams, who again a contributor to this sort of event, because she had her glory night last night.
Thank you very much. It's lovely to see you. Sorry.
Oh, we're losing you, Nicola.
Oh, my screen's gone. My screen's frozen.
No,
hello?
We can hear you. We can hear you.
Hello?
We can hear you.
Hello?
Hearing you.
Can you hear me? Okay, right. Sorry, my internet connection is unstable. Well, Lady Arden, first of all, it's lovely to see you again.
Thank you.
And I have a comment and then a question, if I may. The comment is what you said about imposter syndrome. It absolutely applies not just within the bar and the judiciary, but in other senior professions, including the military. And there are too few women in the military for me to give a concrete example, because anonymity would go. But it absolutely does apply there. But also, bearing in mind that we have now gone down from 3 women in the Supreme Court down to currently just your good self. I know, and I think everyone does know, that there is currently a competition open for an app to apply to replace certainly Lady Black. And the question comes for applications, because might be controversial for the men, but it is true, and I've certainly seen this, that men will apply for a role if they've got 40 to 50% of what's required, but a woman feels she's got to have 120% before she does apply for anything. I can see women nodding, so I know they know what I'm talking about. Do you have any comments on that? Because if women, there are absolutely things that happen which means that women are disadvantaged or rather hobbled from progressing, but there's also internal self-talk, which might make her a very competent woman not want to apply for that role or any other role for which she's perfectly qualified. Do you have anything to say about that? And the other question, if I may, is you talked a lot about diversity and difference and how important it is. And certainly the Supreme Court has been more gender diverse than it is, and I'm sure it will get back up to that again. But it's not racially diverse or ethnically diverse. And that applies to the senior judiciary, not just in the Supreme Court. Do you have any comments about that?
On your first question about applying, I wouldn't like to say that every woman must apply for every job, because a woman's got to decide how she wants to run her life,
Indeed.
How she wants to have work-life balance, or whether she wants to place particular emphasis on success in a job, or whether it's something else that attracts her. And I'm not therefore generalizing, but if you do focus on your work and you're keenly interested in it, and it's what makes you jump out of bed in the morning, then I think Chelsea Clinton was right. Dream big. Just get on and have a go at applying and see what happens. And I hope very much that you will be successful, because I'm sure that much consideration is given now to having women. Now, on the next question, which is diversity, for me, I was very conscious, and I'm very careful to use the word diversity, because to me, it's diversity of every kind. When we look at just the debate about women, it is only a very narrow debate. It's not the totality of the debate. And the debate must certainly include race, ethnicity, and all sorts of different elements of diversity. But I think possibly the gender issue has come up first because more women in the population than men, but secondly, because also the lack of women is very, very visible, but it is also very, very visible for ethnicity and for race. So I hope that now we've got to a certain stage with women, we'll make equal progress with men, and the same advice would apply. More mentoring, more focusing on the needs of that particular applicant and ensuring their talents are recognized. And also more role models. You're a role model, Nicola.
Well, thank you very much. That's a huge compliment coming from you, Lady Arden.
No, I mean it.
Thank you.
Thanks, Nicola. Most of our questions are from women, but we do have some men. So Philip Goldenberg next.
All right. That's Philip.
How lovely to see you again.
And you, Philip? But I can't see you. Where are you?
If you've got full screen, he's at the top next to me.
Okay.
No.
I'll keep trying. Oh, yes, now I can see you, Philip. Hi.
Hi. So I've been told to ask a question as a statutory male. Isn't it the case that on both sides of the gender divide, there are heroes and villains? Although, of course, I take the point the balance is unequal.
Are we stopping there or going on?
Yeah, no, that was it.
Well, it takes all sorts to make the world, of course. I wouldn't necessarily use the term about anybody that they're a villain. I'm not quite sure who you have in mind at this point. I think what we need to do is to focus on those heroes and heroines who do give us leadership. And of course, in every society, there are people who don't necessarily comply with all the rules of society. We must do our best to focus on those who do. Take our lead from them.
Thank you.
Thank you. Kate Birch is next, who is a significant figure in our literary circle.
Yes.
Makes us all read books.
Hello, Lady Arden. Thank you so much.
Not at all.
Now, I have a young woman friend. She's in her mid-20s. She's just started studying law after leaving a job in the city. And this was partly because she was subject to misogyny and sexual harassment, conscious bias, if you will. This, I always found this very disappointing. It was in the same field as my husband, which is reinsurance and insurance. And generally that area is better than some of the hedge fund boys and things like that. I worry about her in the law. Are there protocols protecting women from this kind of thing in the law?
I'm very sorry about her experience, and it must have really been traumatizing for her. But I'm very glad she's changed to the law, because I think part of being a lawyer is not simply learning the law, it is acting out the high standards of the law. So, in other words, you know what the law prevents, but you know why the law is there. It's to instill good order in society and harmony in society, and that everybody works to help their neighbor and doesn't just think of themselves. So I think that that's part of being a lawyer. I think it's inherent in learning the law, and I hope very much that your friend will feel happy in the law and find that she is well placed and able to trust those around her. So far as protocols are concerned, it's difficult to recall them, but there are very high standards set by the bar for barristers in chambers. I would be almost certain that the Law Society has very high standards. And of course, when judges are dealing with people in court, they also have their equal treatment bench book, which sets out very detailed guidance on how judges should act. In any event, that should be as axiomatic if you're a judge, that you're totally impartial and independent. Have I come somewhere near to comforting you about this?
Somewhere.
I think she's made a good decision.
Thank you.
Okay, thanks, Kate. Mariana Cherry next is one of our enthusiastic newer members of the club. Marianne.
Good evening, Lady Arden.
Good
It's
evening.
a real pleasure to see you, and thank you very much for being the trailblazer for other women who are coming after you. I'm not in law at all, but my question is, from your point of view, actually, it's two sort of question A and question B. So, so the first one, in this present predicament where women have to do the childcare, the homeschooling, and having the job duties fulfilled, do you think it's reasonable to expect that at this very moment of time, since the pandemic has begun, and since the lockdown, and since the mothers had to expect and must educate their own children at home? Luckily, my children have grown up, so I can't really sort of, this is not for me, but this is particularly for single mothers and for mothers with the small children who has to do now not only the childcare but also the homeschooling. And this is something that we'd never come across as a society for forever, since the civilized society, where women were expected not only to look after the children but homeschool them as well. Do you think there should be some kind of proposal for financial reimbursement on this part? So for the reason, so perhaps women, instead of, if they're not able to keep a full-time job at this moment, they could be financially reimbursed and switch to, say, for example, a part-time job, and then continue doing their job without loss of the thing. So that's my first question. And the second question, there's obviously huge disparity between men and women, and that's okay, because that's also a privilege to be a woman, for example. That's how I see it. And maybe the reason men and women are not equal, or they're not understanding each other, because boys and girls, they never play in a school together. That includes the games. And I think because boys, they really learn from school how to play team games, team sports, and how to collaborate with each other, and they really know their place in the team, and that's just how it is. Do you think there's at any point we could suggest to schools to have a sex games for boys and girls to play together, so they learn to mingle? Because there's just this, boys, they never get used to the girls, and girls never used to the boys, and the only experience boys have is having a wife or a girlfriend, and that's just not the experience. Not everybody is blessed with that kind of experience, let's say. So maybe we could, as a society, move to the next level, and hopefully when pandemic is over, we can introduce mixed sex games, and so the next generation can learn how to play together and interact with each other and respect each other and get to know each other on a physical, emotional, and, may I say, spiritual level, although I don't think the children, when they're young, they think much about spiritual level as well. So that's my question. Thank you very much.
Well, you've obviously been giving this a huge amount of thought, and I do very much feel for women who are doing all the things that you have mentioned at this moment: the homeschooling, looking after the home, and looking after the children. And it's particularly difficult for the single mothers because they can't get any help. They've got to be there. And I noticed last week the New York Times had started a helpline for women, and it was called The Scream, after Edward Munch's Scream, because women at the end of the day were saying, I never knew how I was going to get through the day. It was so awful. And they were screaming down the phone line. And it's particularly serious for those women in small accommodation and those with children with learning disabilities. I'm sure that they are loving children and do everything, but they feel it too, and it bound to rub off on the mother. I think it's extraordinarily difficult for them, and they are being heroines. When it comes to financial reimbursement, I have to say this is not something I would know the answer to. I would hope that women are being treated sympathetically by their employers or are being furloughed when that was a possibility for them. But they clearly, there's got to be, they shouldn't have financial worries heaped on them as well as what they're doing. So men and women, you say they're not equal. Well, they're certainly different. I would agree with you on that, but there's no reason why they shouldn't be equal. Very often the inequality is just historical. That's the way it was. And so people have assumed that's the right way for it to be. And you've got a very good idea about mingling, children getting together at a younger age instead of being in single-sex education. But I have a feeling that this is done at sixth form level, where there are debating groups or out-of-school activities or even games together. And I can see that that's part of the way forward. I mean, I used to think that that men only got interested in the problems for working women when they themselves had daughters who started getting difficulties because they were looking for a job and found that they weren't being promoted at the same rate as the men. Then the men got really interested. So I agree with the sentiment, but thank you. Thank you very much for the question.
Thanks, Mariana. Chris Holworth now, please. Chris is another enthusiastic, relatively new member.
Thank you, Val, and thank you very much, Lady Arden. This is a more general question, if you like, but if I could pick on the example of the recent very high-profile prorogation case of the Supreme Court, where Lady Hale was seen very publicly and with a huge amount of publicity handing down her judgment. And really, I wonder, with reference with that, if you might comment on how important do you think it is for the public at large to see women and to see women in action in those really top jobs?
I'm not saying anything about the particular case you're referring to, but I do think it's important that, yes, women are visible. I really do. And that's, I suppose, the other side of the role model point, that it's not only those people who want to get into the profession that I'm primarily concerned with them, but it's the rest of society too, accepting that it's normal to have women in leading positions. And I think you make a very good point there. Perhaps I should have brought that out. What do you do, Chris?
I'm actually an IT infrastructure engineer at the Royal Household. So,
all right. So you know.
I wonder, do you think perhaps if it had been a man handing down a judgment of that magnitude or with that amount of impact, would the same publicity have been received? Do you think?
It's very difficult to know the answer to that, but I would have thought that the case you're referring to is one with which there was tremendous public debate anyway. So I'm not sure that one would be a good example.
Thank you.
Thanks, Chris. Next up is Zara, one of our new young members, another enthusiastic member. Over to you, Zara.
Thank you, Lady Arden, for telling your story. My name is Zara Brannigan, and I'm in Year 12 at King Edward's School, Bath. I'm interested in pursuing law after sixth form, and you are one of my role models.
Oh, thank you.
I have two questions. The first is, what would you recommend as a higher education path for women who want to be in the senior judiciary? My second question is, what's your advice for sixth form girls who want to be in the senior judiciary?
I think the answer to both questions would be the same. I read law at a university. I studied law. And people say, well, it's not necessary to study law. You can be a brilliant lawyer if you've read history, natural sciences, anything else, and you've got a broader mind. Well, I accept you probably have a broader range of interests, but I think what I learned at university in intense study of the law was very important. And I've drawn it even now. I think, oh, my professor said this. I'll just follow up that line of reasoning. And it usually leads to something. I did a first degree and then 2 postgraduate degrees. And I think you have plenty of time these days to go on and do postgraduate work. And you should do it.
Thank you.
Good luck. Now.
Sorry, bear with me. I've just lost my list of speakers here.
That's all right.
Technology. There we go. Sorry, Dan Cope. Dan Cope next. There we go, Daniel.
Thank you, Val, and thank you, Lady Arden. That was a very interesting talk, and I must say I do agree with you in the sense that regularly there you do witness bias, whether that be of unconscious nature or conscious nature, whether that be within the micro diversity lens or within the general gender lens. So if I may, my question really relates to gender diversity is obviously a key problem, not just within the judiciary, but within multiple sectors. To name many, of financial services is obviously one of them. And you obviously see the gender diversity is obviously of concern, but so is a micro diversity with many members of minority groups, such as those within LGBT, those as Black Lives Matter, are considered as marginalized. How have you seen the judiciary shape to adapt these diversity strands over your period?
I think the same change for the groups that you mentioned as for women. Namely, there's just been a general change of mood, a general change of gear. Yes, we must be diverse, we must represent society, and we must show that we actually adopt and operate by the egalitarian methodology of the law. And the recent Master of the Rolls has just stepped down, Sir Terence Etherton. He was in fact openly gay and was in a civil marriage and then a same-sex marriage. So civil partnership and then a same-sex marriage when that became possible. But I recall from my career that people who were appointed judges could not be gay. And I recall one person in particular was given the appointment and it was withdrawn when it was discovered that he was gay. So, I mean, that simply wouldn't happen now. The fear was, a fear on the part of the Lord Chancellor was that this person would be subject to pressure if he was gay, subject to pressure from of an undesirable kind, and therefore we shouldn't have any gays. I just don't think that would even come into anybody's thinking. And the same for the other groups you've mentioned, LGBT, same-sex, transgender, Black Lives Matter. I think there's a really great drive to try and bring people in, but there's quite a long lead-in time. You've got to have people in the pipeline. You've got to help them when they start out so that they start becoming ready. We just had a question about what to do at school. And we really do have to go back into people's early years and find out what we need to do to ensure that they get themselves prepared in a position whereby they will come along and be people who will want to be members of the judiciary and actually be appointed.
Thank you, Lady Arden. If I may just enhance that question just slightly, and sorry, Val, I realise I've been cheeky. Obviously, one of the key aspects as you draw there is drawing on younger people getting into the profession. However, there is obviously, especially within those that want to become a barrister, it is selective. If you are rejected by one or all of the houses, you will not. There is no other route realistically. Therefore, that does to create an aspect, wrongly or rightly, of eliteness. And obviously quite often within those houses, it is members that have been established for quite a sizable period, and there's not always a great level of oversight over those committees and boards, etc. So how do we, in obviously your opinion, how do we ensure that is followed through from that ground upwards?
Well, first of all, awareness, making sure that people who make decisions have training about making decisions, of doing it on a fair basis. There's also the economic driver, and that is every set of chambers will want the most able person because they're in competition with the next person, next set. And thirdly, there's a role for the Inns of Court, and I think this may be the answer. It doesn't all depend on your turning up for an interview with the head of chambers and his being an old fuddy-duddy. You go into the inn, and the inn coaches you forward to the stage when you get called, and it's in a sort of pastoral position, and it will help you apply for scholarships and get through your course and give you guidance and may even help you decide which chambers to apply to. But if you go and apply for a scholarship and you get one, and there are lots and lots of scholarships offered, then you've got a point to put on your CV and you're going to be one up in the race. And it's, I think I would say chambers these days operate pretty much on merit.
Thanks.
Thank you.
Isha Zhu is next, one of our very active members and member of General Committee.
She's just left the meeting.
Oh dear. Okay, well, same description. Gillian Kerr, who is also a member of General Committee.
First of all, can you hear me?
Very well.
Oh, fine. Just with you mentioned it coming out of lockdown, if there is a sort of downturn in the economy and women are not quite so strong or able to put themselves forward, how do you think this is going to affect things?
Well, my worry is, of course, that women will do badly out of this. And I think we need to have some planning. It's something, I think, where women, by networking as you are, can help each other, by strengthening people and planning for the next stage. How are they going to get back to work? Most women will be immensely relieved if they've got school-age children that they'll be going back to school, so there's some regularity in their lives again. But what would be terrible if they went back thinking, I've had to spend nearly a year and I haven't been able to do my job as well as I could have done, and I haven't been able to keep up with everything that's going on, so I should take some lower grade. That would be really sad, and we must encourage women not to think that way, that they've been having other experiences, but they'll be up to speed in the same way as I hope British business will be up to speed when we get out of the lockdown.
Thank you very much.
Okay, I think Paul Scully, one of a guest of mine, may have a question, but he's not had time to put it through to Tim. So, but he has put it through to me. Right. Paul.
Thank you, Val, and thank you, Lady Arden, for an excellent talk. It's not an equality-specific question, if I may go slightly off-piste, but I've, like many other lawyers, been terribly concerned over the last year or two about attacks on the profession, the judiciary, as enemies of the people, and now what appears to be a potentially veiled attempt to look at whether judicial review proceedings ought to be restricted. And it would be quite wrong of me to ask you to express a specific view about that. But if you can comment generally on the relationship between the judiciary, Parliament and the press at present, I'd very much welcome your views.
Well, I think I should probably not go down that route, because obviously the Parliament has to decide what the law is that we're going to apply. And if it decides to make new rules, we will have to apply the new rules. But I would like to say this. I spent 13 years as head of international judicial relations for England and Wales. And that meant that I had to talk, and I was delighted to do it, talk to people in other jurisdictions about what was good about English law. There are lots of good things about English law, which I could bore you stiff for the entire evening. But its commercial law is very important. It's used by lots of businesses across the world because it is so flexible and adaptable and up to date. But they also like English law and coming to, because if they choose English law and can come to the English courts, they get the English judiciary, which has a reputation for independence and objectivity, and also for competence and knowing the law. And what I feel very strongly is that judges play their role in the promotion of the legal rule of law and in its operation. We live in a peaceful society, and we have been very lucky to do so for so long, because everybody respects the law, and it's important that society continues to operate that way. And the way it will happen, or one of the main contributing factors, is if we continue to have judges who are as committed to seeing that the law is properly applied as they are at the moment, and who are able to do their job objectively and independently.
Thanks very much. We're rapidly coming to a close, which is coincidental with the fact I've run out of questions in any case. So I'll pass over to Emma Moore.
I've been given the absolute honour of saying the vote of thanks to the Right Honourable Lady Justice Arden. Thank you very much. For those of you who don't know, I'm also the chair of the Sustainability Forum. As you know, that's number 5 for the SDGs, which is gender equality. Yes. And on a side note, I'd actually quite like to say, because I'm 35, very happy to admit that, when I went through school, I very much expected to be treated equally when I got to the workforce. And I would suggest that for a lot of females coming through, that absolutely is happening because of women like you. So I think the reality is, for us, we don't know a world that's any different. We haven't experienced that. And I'd very much like, for the disadvantage that I've had in my career as a criminologist, to not be seen by the next generation, and we can really get there if we all move together. So I just want to say a massive thank you for coming and being a mentor. That's much appreciated. And also thank you to Tim, Val, and also Tim McNally for running the event and doing all the behind the scenes stuff. Thank you all very much for coming. The Women's Network, by the way, is fabulous for the NLC. So thank you very much, Val.
Oh, thank you. Thank you. It's time to say a final, really, thank you very much, Lady Arden. Everyone's enjoyed it as far as I can see from the chat room. For those who are not zoomed out, you can switch over on another link on the same email to our Thursday table for what's left of it until 8 o'clock. So thanks all very much, and see you all soon.
Can I just say thank you to Emma and to you and to all of you for very interesting questions and for listening so patiently. And I've thoroughly enjoyed myself.
Thank you very much. Thank you so much.
Thank you. Bye now.
Bye-bye.
Good luck, everybody.